Test, test, test.
Colleagues, distinguished representatives of Suriname, the audience here, the conference services and interpreters, good afternoon to everyone. We're now going to begin the meeting 3208 of the Human Rights Committee. I'm joining the work of the committee that began on Monday with excellent work on the part of those who have chaired the various sessions in the various chambers. I'd like to thank Ms. Seibertford, Mr. Vasilashvili, Mr. Situ Singh for the efforts that they have made while I was at the General Assembly in New York. I just arrived just 1 hour ago from my trip from New York to Geneva. I would like to wish a very warm welcome to the representatives of the distinguished delegation of Suriname, led by their head of delegation, His Excellency Henry MacDonald. We really do appreciate having you here with us. I'd also like to say that in our committee we have Ms. Marva Waterval, a colleague from Suriname who has contributed greatly to the work of the committee during 1.5 mandates already, and it really is a great pleasure to have her working with us. So I would also like to thank the State Party for that. We are very happy to have Suriname here. Suriname is a state that's also a state party of the Inter-American human rights system, and the Inter-American Court of Human Rights inaugurated its political order. It was the first case that recognized it in terms of the case of Arauto, where the state, in very good faith, decided not to contest the substance of the case. It recognized its responsibility and decided to open discussions into reparation. We are here to review the third periodic report of Suriname, and the session will take place as follows. I will give the floor, first of all, to His Excellency Henry MacDonald for his presentation and to give a summary of the replies to the list of issues, which unfortunately came in somewhat late, which made it quite difficult for our colleagues to work on it as closely as they might have liked. So in any case, we will have a summary of the replies to the list of issues. Then we will move on to the dialogue. This will consist of, first of all, a discussion of the first part of the list of issues, issues 1 to 13 on the list of issues. The members of the committee will put forward questions and comments on these issues, and then we will give the delegation some time to prepare their replies. We will then have time for follow-up questions, and this is what we are going to work on this afternoon. So with no further delay, I will now give the floor to His Excellency, Mr. Henry MacDonald, to give his presentation and a summary of the replies to the list of issues. You have the floor, sir.
Thank you very much, Mr. Chairperson. First of all, let me say that we are happy to be here. And I'm happy as well that we are happy as well that you have been able to make it, coming from New York as a former chairperson of the third committee. I think it was the 67th session. I always attend the meetings of the third committee, and certainly when the chairperson of the committee will address us there. But fortunately, you're sitting next to me, so I'm really great that you are able to make it. As you said and as you requested, I will give a brief summary of the list of reply, and then I will immediately go into the substantive parts, the questions. I will not do all the questions. I will take a number, and then my colleagues are coming from Suriname. One is senior legal officer at our embassy in France, just next door, and he will also take a few of the substantive questions. Uh, Chairperson, distinguished chairperson, members of the committee, and the civil society representative, TIFs all the way in the back. At the outset, I would like to, on behalf of the government of the Republic of Suriname, express gratitude for the opportunity to have a constructive dialogue with the members of the committee to discuss the implementation of the International Covenant on Civil and Political Rights in accordance with Article 40 thereof. Allow me first to introduce the members of the delegation. Mr. Abu Jones is the second secretary at the Embassy of the Republic of Suriname in Paris. Abu is sitting to my far left. And next to me is Ms. Armilia Joso Toyo Semito, Senior Legal Officer of the Ministry of Foreign Affairs from Capital, from Suriname. And I'm the ambassador at the United Nations. I'm the permanent representative, and my name is Henry MacDonald. At the outset, I wish to inform that the government of the Republic of Suriname deemed it of the utmost importance to assign a delegation for this dialogue. Allow me to reiterate the unwavering support of the Surinamese government for the promotion and protection of all human rights and the commitment to uphold our national and international human rights obligations. Distinguished chairpersons and committee members, we would like to thank the committee for preparing the list of issues to guide our discussion with the committee. The delegation would like to apologize for not having the responses to the list of issues available for the members of the committee in a timely manner. And with regard to not being able to be in time and to be prudent and exactly in time, I want to inform the committee that Suriname is a very small country. We have a lot of challenges. And also with regard to the reporting to human rights treaty bodies. I can tell you that so far I have been in almost all the representations. While I'm the ambassador in New York, 3 or 4 months ago I was here in Geneva for was it racial discrimination? Yeah, racial discrimination. But in the past I have been, and some of them racial discrimination was my second time, and I've been in all the others. One of the difficulties which we had was we had elections on the 25th of May. And after the elections, we were in the position of putting in place an administration. The administration was put in place on the 12th of August. And of course, the new ministers of justice and Foreign Affairs wanted to take a look at this report. We also were then, after the ministers were in place, then I needed to start for the General Assembly. The General Assembly came with the adoption of the SDGs, and thereafter, immediately, third committee started, and this all needs to be done by just a few persons. Another interesting thing is that, as I said, I've been in this work for a few years, but for many years. But the person who was in the past responsible for these reports was one of my former students, who is now a member of the committee. And since she is in the committee, she cannot do that work anymore, preparing reports, and not even. I came here in New York and here in Geneva yesterday. I haven't seen her even. But that is how it is. And that is one expert which was in Suriname working on these reports, cannot do it anymore. And in the past, we didn't have a new breed of experts who can take over from us. My two colleagues here is their first time. They are very nervous. They have been doing this for a few months, I think. Madam here is from the Ministry of Foreign Affairs, Judicial Department, and we just grab them and they need to. And I hope that they will, that they will take it from us because we have done a lot. We have worked hard, but even I'm getting older now, and it is time for us to, to let a new breed. And I just told them how exciting it is and how their career will flourish, just like you, and that maybe one day, if they are quickly, I can start do their campaigning so that they can be elected. But that is a definite. Those are definitely a lot of challenges. One challenge is also the language. Dutch is the official language in Suriname. So if we send something to the Ministry of Justice to have them to ask them for prison information and stuff like that, they will send all the information in Dutch. So then we will put down the report in Dutch, and then it needs to be translated. And when it's translated, then experts need to read it again. So it is a real a big challenge. But as I said, we are committed. We have a few people back home who are really serious with human rights issues. I'm in New York and I'm always pressing my government for these issues as well. And that's why we are here, but we will do our best to present the report and to give you all the information we have in a frankly manner. So therefore, allow me to briefly summarize the responses to the list of issues. Within the legal proceedings of Suriname, lawyers regularly refer to the International Human Rights Conventions as part of their defense strategy. The court also refers in their decisions regularly to the conventions. In the scope of institutional capacity, strengthening human rights training courses were conducted for police officials, the media, religious organizations, and non-governmental organizations. In April 2015, this year, the state established the National Human Rights Institute by government regulation, and it went into force on March. It was established in April and it went into force this year. In the past period, the state of Suriname has published several laws and administrative measures that should combat all forms of discrimination in line with Article 8 of the Constitution of Suriname. With regard to the differences in the employment rate of men and women, the state wished to refer to the attachment to the report that gives a statistical overview of the number of men and women employed in the age category of between 15 and 64 years of age by ethnicity. With regard to amend discriminatory provisions concerning the minimum age of marriage, which differs for men and women, the state like to stress that it has already taken steps by submitted the amended civil code for approval to the National Assembly in regard to the marriageable age of boys and girls to be equal an age of 18 years. The state has initiated the execution of the policy plan 2005 and 2010 of the Commission regarding policy for people with disability. And a number of matters in the field of law and legislation, education and training, recreation and sport and transportation have been addressed and realized. Although there is no specific law that harmonizes the proclamation of the state of emergency with the specific requirements of the convention, the state built in a guarantee out of its responsibility. To declare the state of emergency, the President of the Republic of Suriname needs permission of the National Assembly, the Parliament, which means that the people can assure that its civil and political rights are not put aside. With respect to violence against women, the state indicates that measures are already being taken to combat violence against women by the adoption of the Act to Combat Domestic Violence in 2009. the statistical overview of the number of cases for which a protection order was granted in the period of 2012 to 2015 is attached to the report as well. With respect to the right to life, the state would like to inform the committee that the amended penal code abolishing the death penalty became effective on the 13th of April this year, 13th of April 2015. The state also conducts a zero tolerance policy when it concerns unlawful police actions. Unlawful police actions are investigated irrespective of persons, and in case they are found guilty, and I mean the police officers are found guilty, either penal or disciplinary actions will follow. With regard to the allegations that arbitrary detentions, harassment, torture, and ill treatment against LGBTI persons, especially transgender women, the state wishes to indicate that there is no factually substantiated information available on that ground. The actual situation in Suriname is that the LGBTI community can freely move in society. And later on, when we go into the substantive matters, we will elaborate a little bit more on that. With respect to the elimination of slavery and servitude, steps were taken in cases of human trafficking, and will further and on that we will also further elaborate on this matter. In regard to the right to liberty and security of persons, rights of persons deprived of their liberty, right to a fair trial and due process, we will elaborate on this more during the presentation tomorrow morning. Concerning the freedom of peaceful association and assembly, the state wishes to note that there is no formal complaint known in which the enjoyment of these rights granted by the Constitution to everyone who finds himself or herself in the territory of Suriname is hindered. With regard to the concern expressed by the committee regarding child abuse and the eradication of sexual exploitation, the state has taken measures by adopting the amendment of the penal code related to the protection of children. The state wishes to emphasize that in the 40 years of its existence as an independent state, all forms of corporal punishment have been criminalized by law. In the Surinamese reality and composition of our population, we do not use the term minorities because of various ethnicities, or because of various ethnicities in Suriname. There are, for instance, not one single dominant group in the country. And during our deliberations tomorrow, we will also explain a little bit more what we mean with this. Mr. Chairman, that was my brief summary of what we have submitted. And if you give me permission now, I will then continue with the specific questions and the answers that we formulated. Thank you very much, Excellency. As said before, was laid out by the President, by the Chairperson. We will now present and discuss the question 1 to 13, and then tomorrow we will take 14 to 26. Constitutional and legal framework within which the covenant is implemented. Article 2. Within the legal proceedings of Suriname, lawyers regularly refer to international human rights conventions as part of their defense strategy. The court also refers in their decisions to rights that are enshrined, for example, in the ICCPR. And in case of the lawfulness test of police custody, lawyers also often invoke Article number 9, paragraph 3 of the ICCPR. However, the judgments involving the application of provisions of the ICCPR or the use of aforementioned provisions of the Convention as an aid to interpret legal legislation has not been separately filed in the archives, and judgments are often not filed because of their content. There are, however, cases known in which the court has used the ICCPR criteria to explain the reasonable term within which a suspect has to appear before the court. In the first half of 2015, human rights training courses were conducted for police, surgeons in training, and police inspectors. Police sergeants in training and police inspectors. The goal of the training was focused on providing the participants knowledge of the content of human rights conventions and the correct manner in which and when coercive measures are allowed to be used, so that no action are taken in contravention of the Human Rights Convention. During this training, the following sources of human rights were highlighted. More in particular, the Constitution, International Covenant on Civil and Political Rights, the Conventions on the Rights of the Child, the American Declaration of the Rights and Duties of Men, the European Convention on Human Rights, the Universal Declaration of Human Rights and Criminal Procedures, and human rights are furthermore included as a subject within the police training.
Su Excelencia, si me permite.
Your Excellency, if you will allow me, I would like to state, as we do indeed need some time to carry out the interactive dialogue suitably, what I would ask the delegation to do is that you provide a summary of the replies and not read through all of the replies that you have, because if you do so, we won't have enough time to hold the dialogue afterwards. So if you could give us a short summary of the replies that are contained within that document, so that then we can move on to the interactive document. Taking into account that we received the replies to the list of issues with very little time to read through, but we don't need you to read through all of the replies that you have there. So I apologize if I'm perhaps abusing the delegation somewhat, but perhaps you would be able to give a summary of the replies that you have so that we can then move on to the dialogue. Thank you very much, and I give the floor back to Your Excellency.
Thank you very much, Chairperson. The first part what I read was the summary. And that was quite brief, but that was a summary of what we submitted. And the second part was what we prepared was to go directly into the questions, and that was I thought that was what we were asked to do, to give a summary, and that was quite fast. That was just a brief summary of everything, and then we would like, if possible, the opportunity to dwell a little bit more on what I've said in first instance.
Of course. Go ahead.
With reference to the information provided in paragraph 46 of the State Report, the National Assembly adopted in 2012 the Amnesty Act, which is actually an elaboration of the Amnesty Act of 1992. And ever since, the 8 December trials have been suspended until the Constitutional Court has given an option on the Amnesty Act. The case Baburam Adin et al. Against the state of Suriname regards the referred trial. This means that this case, to which the Amnesty Act also applies, cannot be further prosecuted. Upon the adoption of the 2012 Amnesty Act, it was established in conformity with Article 4 that immediately upon the publication of this act, a Truth and Reconciliation Commission will be established by law for the investigation and truth-finding about human rights violations in the period from 1980 to 1985, including the events of the 8th of December the 8th, 1982. As long as the Amnesty Act is in force, the state is held to comply with this law and to implement it. This law does not offer the state legally the room to implement the recommendations of the Human Rights Committee in the case of Baburam et Adin et al. Against the state of Suriname. With respect to non-discrimination and equality between men and women, Articles 2, 3, and 26. Annex 1 of the report, Total Employed Population, provides a statistical overview of the number of men and women employed in the age category of 15 and 64 of age, and this is in ethnicity. From this overview appears that the number of men employed is not even 2 times as much as the number of women employed. However, what should be taken into account is the fact that Suriname, because of its many ethnicities, also has a multitude of cultures. With regard to the salaries, no distinction is made between men and women. Large companies with collective bargaining agreements have in most cases also salary scales that link a salary to a function. In smaller companies, a possible difference in salary is not visible. However, the aggravated party always has the possibility to submit a complaint with the Ministry of Labor to take legal measures against the employer. In addition, the state has put the Act on minimum hourly wages in effect in 2014. Furthermore, can be indicated that the National Bureau of Gender Policy is currently evaluating the Gender Work Plan of 2013. Labor is one of the 5 priority areas that are mentioned in this work. The state will pursue that the topic of full participation and advancement in the workplace, in addition to other topics, is included in the different discussions that will be held with relevant stakeholders in connection with the formulating of the Gender Policy 2016-2020. In addition, the state has signed the program, Decent Work Country Program 2015-2016, in January of this year with the ILO Sub-Regional Office for the Caribbean and social partners. And the result achieved within the framework of this program are the establishment of a labor market information system, studies in the labor market and studies into salaries to identify a trend and inadequacies. In the period 2014-2015, the NGO Stats International conducted a national promotion and awareness raising campaign with the title More Female Leadership in 2015, which was supported by the Ministry of Home Affairs. The goal of this campaign was to show the importance of participation of women in political and economic decision-making and to increase public and political awareness in the field. These activities resulted in an increase in the number of women in the parliament from 5 women in 2010 to 14 women in 2015. I can say that I was personally part of this, and I was asked by the government to go to Suriname and I speak in parliament, and there was an entire campaign that was financed by the government, where all female candidates, first of all, there was a campaign to inform the political parties to put women on the ballot box, on the ballot list. And then the government paid for all female candidates. They paid for a campaign in order to promote them with billboards and television programs, radio programs, and there was also a meeting in Parliament in order to, to inform the population that it is important for women to be elected. And it was, a few things were simple. Women are half of the population. You need to see them in every single sphere of life, and certainly in politics. And we were able to raise the numbers, as I said, from 5 women in parliament to 14. That is almost 30%, from 8% to almost 30%. And I can tell you that we were able to do that without a quota. Because interesting is, I'm somebody who speak up for women's rights, also at the United Nations. And it was, in many countries, the opposition and the coalition always have issues with each other. They don't support each other quite often. But if there was one issue where the opposition and the coalition was in Suriname was that they have one voice, was no quota. So that quota thing didn't work, so the government then took another step in order to work on increasing the numbers of female parliamentarians. And I can say that personally, I'm really proud, since the Secretary General of the United Nations, in a bilateral meeting with him last month, this was the first thing which he mentioned, that he congratulated us that we were able to bring the number from a terrible 8% to 30%. We know that we are not there yet. The global average is 22. Of course, we will be happy when it is 50, and we will keep on working on that. But it was a challenge, and we were able to get quite successful results. With regard to women in the government, in the administration, of the 17 ministries, we had only one female minister. That number was raised to 4. We were pushing for 5. We didn't make 5, we make 4. I think the Minister of Justice is a woman. The Minister of Foreign Affairs is a woman. The Minister of Social Affairs is the woman, and the Minister of Trade and Industry is also a woman. So we are working hard on these issues, and for us, it is important. For me personally, I can also inform the committee that in New York, Suriname, and Iceland, we took the bold initiative to organize a special conference, a barbershop conference. And the goal of that conference was to approach men, the male diplomats at the United Nations, and at that meeting almost 400 came, and to inform them why it is just a good thing, it is the right thing to do to support gender equality and empower women and make sure that this ongoing violence against women, that it stops. So we are busy back home. We are busy in the region, and also on the international level, we are trying to do whatever we can to make sure that the biggest human rights violation, and that is violence against women, that we can do something. And the twist that Suriname is bringing in, and Iceland, is to bring men into the conversation so that men can understand that it's not cool to just say that I'm not abusing my wife or my girlfriend, so I'm okay. Men need to know that they need to speak up, that they need to be more active, that they need to approach their friends and their other male colleagues in case they heard of something wrong. With regard to the information containing paragraph 216 of the periodic reports, on the 25th of September 2015, the National Assembly approved the accession of Suriname to the Convention on the Rights of Persons with Disabilities. In anticipation to this, the state has initiated the policy plan of 2005-2010 of the Commission regarding policy for people with disability. A number of matters in the field of law and legislation, education and training, recreation and sport, and transportation have been addressed and realized. Within this framework, the following can be listed. And the total list, we have produced that list already in writing, so I will not read the entire list right now. Violence against women, including domestic violence, Article 3 and 7. Between 2012 and 2015, 520 cases of violence against women were reported to the Public Prosecution Department, of which 304 involved domestic violence and 216 stalking. In 47 cases, the Prosecutor's Department restored the prosecution, after which judgment was given, and in the other cases, out-of-court measures were taken against the offenders. As a measure to combat violence against women, the state has adopted in 2009 the Act to combat domestic violence in 2009. This act offers women, amongst other things, the possibility to submit the request for a court order with the courts, to be able to faster identify the cases of domestic violence and to make the action of the police more efficient and effective. In the past period, different types of training were given to the police. In the interest of progress of the training to combat domestic violence, training for trainers regarding domestic violence was given. Within this framework, investigative courses were also given and a workshop on children and sexual offenses legislation took place. Furthermore, training was provided for judges, public prosecutors, social workers, and the staff of the Ministry of Justice and police officers with regard to applying the legislation for addressing and combating domestic violence. I would also like to say at this time that Suriname is supporting the He for She project at UN Women. I'm a He for She spokesperson, and Suriname next month. I know that the Ministry of Internal Affairs is busy to organize a huge campaign back home. I think we are approaching the president to be present and to say, to give the lead. And in that regard, also on the 16 days of activism against domestic violence, which will start on the 25th of November, we will have campaigns, and also the barbershop idea will come up. We'll introduce it back home as well. The right to life and prohibition of torture and other cruel, inhumane, and degrading treatment or punishment. And I think that I will come to the end of my presentation with this. The amendment of the Amnesty Act of August 19, 1992 was an initiative by a number of legislators in line with the principle of equality enshrined in Article 8 of the Constitution of the Republic of Suriname. Article 8 reads as follows: all who are within the territory of Suriname shall have an equal claim to protection of person and property. No one shall be discriminated against on the grounds of birth, sex, race, language, religion, origin, education, political beliefs, economic positions, or any other status. It can be recalled that pending the recent Amnesty Act of April 5, 2012, two similar acts were previously passed by the legislature. Therefore, this decision was taken in order to end the discriminatory aspects of the 1992 Amnesty Act, which solely and explicitly covers all criminal offenses as defined by that law and that committed in the period from January 1st, 1985 through August 19, 1992, and thus only concentrate on that what occurred between 1980 and 1992. The amendment of the Amnesty Act of August 1992 is a mere rectification of the arbitrary decision in said act, where for reasons apparently of political interest, the retroactive effect of that act was only authorized starting from January 1st, 1985. It should also be pointed out that this amendment is simply a qualitative expansion of the previous piece of legislation. The introduction of the explicit call for the establishment of a Truth and Reconciliation Commission implies a qualitative improvement of the previous act, since its precursor did not whatsoever call for mandated the creation of a procedure to seek truth and reconciliation regarding the violations and crimes it covers. Nationally as well as internationally, the Surinamese authorities did not receive any official expression or concern with regard to the adoption of the Amnesty Act of 1992 for granting a general and official pardon to those who committed crimes against the states of Suriname or its citizens. It should also be noted that back then a general and unconditional pardon was granted to the initiators and the persons who took part in the civil war, which even made use of mercenaries during those ghastly days of the domestic war in Suriname. The Amnesty Act of 1989, nor its amendments in time sequence, conflicts with the standards of international law, since crimes against humanity, as stipulated in Article 2 of said Act, and its modification in conjunction with Article 7 of the Rome Statute are clearly not exempt from prosecution. Crime against humanity, according to Article 7 of the Rome Statute, means the following, and I quote, crimes against humanity means any of the following act when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack, murder, rape, slavery, etc. In 1992, the government of Suriname, by adopting the Amnesty Act 1992, decided to grant an official pardon and amnesty to those who committed crimes against the state of Suriname and its citizens in the period January 1st, 1995 to August 19, 1992, in order to facilitate a much-needed peace and reconciliation in the country. The government could have endeavored to investigate and prosecute the suspect, but wisely decided not to do so and choose for the larger goal in the interest of the country and its population. This policy was in fact widely accepted by the world community. A perfect example is the sequence on the December 8 trial, which has been going on for more than a decade. To date, testimonies of all witnesses have been taken, and still the real truth has not been heard nor detected in the opinion of many citizens due to the various technical, judicial, and administrative mishaps of this trial. Also, many potential witnesses have in the meantime deceased. Looking back at all this, many, including members of the parliament today, understand and respect the wisdom behind the approach and decision taken by the then National Assembly of Suriname. It is therefore difficult to understand the remarks made and the manifest lack of understanding made by some of the International Human Rights Committee and one former colonial power regarding the amendment of 1992 Act, Amnesty Act, since this methodology is mere continuation of the approach and decision that was taken in 1992 by the government of the Republic of Suriname. Referring to the May 2010 elections in Suriname, it is also clear that the majority of the electorate in Suriname opted for a peaceful way regarding the settlement of all issues with regard to their past. The amendment of the Amnesty Act of April 17 is in line with the will and aspiration of the population expressed during the recent elections in Suriname. Since the Amnesty Act was adopted within the constitutional realm of the Republic of Suriname, it is in reality focuses on Suriname's plea and quest for real peace, national reconciliation, and closure of 12 years of distress in the country. It furthermore aims at seeking the real truth about the many occurrences during the period mentioned, as well as reconciliation and atonement. After about 30 years, the current Parliament of Suriname has taken the bold decision to generate and offer a genuine and forward-looking environment to the Surinamese community in search of the truth towards reconciliation. The Parliament of Suriname has also endeavored to offer an opportunity to seek the truth in a transparent and unbiased environment. The legitimate plea for a commission of truth and reconciliation, as requested by the Special Conference in 1998 and recently by the European Union and others, can now finally be established.
Señor jefe de la delegación.
Head of delegation. We have now reached the point at which we should give the floor to members of the committee to ask questions. I know that you have got more information to provide us, but you will have an opportunity to do so during the course of the interactive dialogue. I'm sure that you'll understand that for reasons of time, we have to try and work as efficiently as possible during the dialogue. Thank you very much for the information you've provided us with, and we will now start with the statements made by the members of the committee. I have a number of speakers on my list already. The first is Mr. Rodriguez Restia, and he will now have the floor. Thank you, Chair. Welcome, Excellency, and representatives of the delegation from Suriname. Having listened to your statement, do not worry. We all become nervous when there is a reference to an examination by the committee which deals with this convention. This is why we call this exercise a constructive dialogue, and I do hope that it will be constructive. Indeed, I've listened carefully to your opening remarks concerning cooperation with the committee and your concerns about human rights. I witnessed an example of good practice in the Lituyu Coast before the Inter-American Court of Human Rights. This led to a reform in Suriname and also led to the adoption of good practices in other states as well. However, in reviewing the situation of civil and political rights in your country, I was struck by a number of issues pertaining to the legislative framework. And so I would like to focus on Articles 1, 2 and 3 in my questions, and then I will also look at some issues which have struck me in your replies to the list of issues, because we only received this 24 hours ago and we've been trying to work so that we're up to date on some of the issues. I fear that we may not be able to give you justice because we may not have read the latest information. I notice that you refer to inclusive approach to drawing up these reports, but we haven't seen any civil society organisations involved, so I'd like to know what efforts are being made by the state in order to promote or to foster the promotion and protection of human rights in the state. And I'd also like to know what efforts are being made to create platforms for civil society organisations to work in the human rights. I have to say that I commend, the way in which you are approaching the processes which are linked to your membership of the United Nations and the Inter-American system by creating relevant institutions. You refer to the fact that you have established a national human rights institution, which we presume will include the figure of an ombudsman. We're not clear on this information. We know that, first of all, you set up a human rights committee within the executive branch, but we would like to know if this new national human rights institution will correspond to the figure of an ombudsman, regardless of the name that you choose to give to this institution. And also, on the legislative framework, I would like, or beyond the legislative framework, I would like to know the remit, the structure, and the finances given to ensure that this institution can be independent and can fully comply with the Paris Principles. I have to say that this is an issue which is of some concern to this committee, so we would like further clarification. Also, you provide us with information on the legislative framework and how the Constitution's Articles 106 and 137 set a clear hierarchy amongst domestic instruments and international instruments, and exactly the position of this covenant. However, could you provide us with clear information within the next 48 hours? There should be tangible information of exactly how the covenant can be invoked in domestic law. We'd like to know if there are specific cases, if there are direct references to the covenant in civil, criminal and other proceedings. We'd also like to know what is happening with regard to the way in which the Constitutional Court could ensure that the covenant is applied throughout the court system. Could you also provide us with information about the courses provided to the police on the implementation of the covenant for police forces, because we know that it's very important to ensure that judges, prosecutors and the public legal service be provided with training on the covenant, as well as all those involved in the justice system. We would also like further information about the implementation of our views on the Babaram Adim case. It's not just that you're not going to comply with the views, it's why you're not going to comply with those views that are of great concern to us. So perhaps we can come back to this in greater detail later on in the dialogue when we talk about the impact of the amendment to the Amnesty Act of 1992. We have to follow up on the impact and the efficiency of the communications that we deal with. This is an old case from Suriname, and we have to make sure that our follow-up is serious so that we can provide an answer to the victims. I have to say that we are left in some doubt by the government's reply on this case, so I will leave my 3 questions there, but I reserve the right to come back in further detail later on. Thank you very much. The Chair, thank you very much, Mr. Rodriguez-Recia.
My list is Mr. Fatala. You have the floor, sir.
Thank you very much, Mr. Chairman. I would like to welcome the delegation of Suriname, and I personally know how it is difficult for such a delegation to deal with the issue, and particularly representing a small country and the burden they have to deal not only with this issue but with many other issues. I will be dealing with the issues number 4, 5, 6, and 7. In relation to issue number 4, this issue is related to the legislative and administrative measures relating to the protection against discrimination. In your reply, either the explanation given this afternoon orally or the written reply is very general, and in the written reply, states give only two examples with no details. They are referring to the Act on Nationality and Residency and the Act of the 30th of March 2015 containing further amendment to the Penal Code. But it was not clear from the reply what is the substance of these two legal documents, and also how they are dealing with the issue of combating all form of discrimination. We know in the committee that you have a nationality law. This nationality law provides that all persons born in the country are eligible to be registered irrespective of the nationality and legal status of the child's parents in the country, which is a part of it is combating the discrimination between the newly born and in the future there will be the adult and in the country. But however, we got some information that in practice, foreign parents are often asked to produce proof of their stay permit in the country before being able to register their child. Fear of being identified and punished by migration authorities, the parents, the parents they don't proceed with the registration, therefore they don't register the newly born. Failure to document a person's legal existence can prevent the effective enjoyment of a range of human rights, including education and health, which is partly fall under the issue of racial discrimination. Suriname has an obligation under Article 24 of the ICCPR, as you know, to ensure birth registration of all migrant children, regardless of their legal status. Therefore, my question is, what legal and practical measures have been undertaken or taken to overcome such difficulties in civil registration in order to combat any form of discrimination? The second part of this issue 4 is related to the recent court decision. You stated, and I quote in your reply, that such distinctions are not made. Against this background, the request referred to cannot be fulfilled. I personally did not understand well your reply, because our question is really clear. Do you have any decisions of court related to combating all forms of discrimination? Which means if someone is having a case that he has been discriminated based on whatever sex, color, whatever, is the court dealing with such case? And do you have example of decisions to combat any form of discrimination when it goes to the court? This is the second part of issue number 4. Now I'll deal with issue number 5, which relates to segregation in the labor market between men and women. Thanks for providing the requested statistics, which proves that there is positive development in order to achieve this aim. As for the non-discrepancy between men and women with regard to salaries, you did provide information related to salaries in companies, but what about the administration, which include, sure, the government? Please provide us with information in this regard. Paragraph 48 of your report states that the Ministry of Home Affairs started the process of modernizing the Complete Personal Act, which process was expected to be finalized in 2013. Has this act been finalized? If yes, what are the main provisions which abolishes completely any discrimination? As for the measure taken by Suriname to promote an equal representation of women in decision making. We got a reply concerning such promotion in the public sector, but not in private sector. Please provide information on the latest. That means how the promotion is done in the private sector. Also, we did not get a reply whether Suriname evaluated the effectiveness of the measures taken to implement the National Gender Action Plan 2006-2011. I turn now to issue number 6. We welcome the submission of the government of Suriname of the bill on the new civil code for approval to the National Assembly, where the age of marriage of boys and girls is increased to the equal age of 18, and you already emphasized that in your oral presentation this afternoon. But my question is, when is this bill expected to be treated by the National Assembly? We also welcome the amendment of the Act Nationality and Residency, which covers a large number of our concern, as reflected in the committee's question number 6, and I have no more comment on this issue because I think that mainly it is covered by your reply. Turning to issue number 7, the reply to this issue is mostly satisfactory, and we welcome your accession to the Convention on the Rights of Persons with Disabilities and the execution of the Policy Plan for People with Disabilities 2005-2010, but we need more information about this issue of disability. For instance, do you have quotas offered for job for disabled person? What about their representation in various bodies, including the parliament? Do you have a law also regulating their contribution or their participation in the private sector, etc.? Therefore, we need to have a practical implementation of what has been already stated by you in the written reply. Thank you, Mr. Chair.
Thank you very much, Mr. Fatala. And now I pass the floor to the following person. Is Ms. Cleveland. You have the floor, madam.
Thank you, Mr. Chairperson, and I would like to welcome Ambassador McDonald and the distinguished delegation from Suriname. We do appreciate the efforts you've made to engage with us both in writing and in person, and I'm looking forward to the dialogue today. I will be addressing issues 8, 10, and 11. And first, starting with issue 8, which addresses the state of emergency provisions of your Constitution and their consistency with our covenant. Article 23 of the Constitution provides that in case of war, danger of war, state of siege or state of emergency, or for reasons of state security, public order, and good morals, the rights in the Constitution may be limited by law for a certain time, depending on the circumstances, in compliance with the international rules applicable in respect thereof. In our prior concluding observations, the last time that you appeared, in paragraph 9, we urged the state to ensure that this provision is interpreted in conformity with the covenant and in particular Article 4. In your submissions and in your remarks today, you note that ordinarily a state of emergency under the Constitution requires the consent of the National Assembly. And in your written submissions, you also stated that Article 23 is consistent with Article 4 of the Covenant because situations that constitute the criteria in Article 23, war, danger of war, etc., constitute, as you put it, a threat to the well-being of the nation and its existence. I would note that legislative participation can be an important procedural check on impositions of emergencies, but the covenant also imposes substantive limits on the ability of a state party to derogate from its human rights obligations. Reasons of state security, public order, and good morals, for example, do not necessarily satisfy the requirement of an exceptional threat of a public emergency threatening the life of the nation within the meaning of Article 4. Article 4 also imposes a number of additional requirements. Any derogation must be proportionate. It must be only to the extent strictly required by the exigencies of the situation. It must not discriminate in the application of covenant rights, and a number of covenant rights are non-derogable. Under Article 23, I would note your Constitution provides expressly that limitations imposed under that article must be in compliance with the international rules applicable in respect thereof. This provision appears to expressly incorporate Suriname's obligations under international law, including under the covenant. I would ask you to confirm if this is your interpretation, and ask what measures you have taken or intend to take to ensure that Article 23 is interpreted consistent with these covenant requirements. Turning to issue 10 and the death penalty, we very much welcome your information, as you've noted again today, that the National Assembly's amendment to the Penal Code to remove the death penalty has gone into effect. My questions are, does this amendment apply to the military penal code? And if not, does Suriname intend to repeal the death penalty under the military code? And then second, in light of Suriname's acceptance of the Human Rights Council's recommendation to ratify our second optional protocol during your Universal Periodic Review in 2011, can you please also inform the committee of your plans regarding ratification of that protocol? Finally, turning to issue 11 and the issue of the amnesty amendment and accountability for past violations. We are very concerned about the lack of progress with respect to criminal investigations and prosecutions into violations that occurred under the military rule, the regression that is reflected by the 2012 amnesty law, and the resulting risk of impunity. When Suriname last appeared before us in 2004, we then expressed concern regarding the continued impunity of those responsible for violations committed during the period of military rule, in particular the murders of 8 December 1982, which were also addressed in our views in the Bobaram Adin case and the Moiwana massacre of 1986. At that time, in 2004, we recommended that Suriname give special priority to bringing the perpetrators of human rights violations to justice, including police and military personnel, and we emphasized that perpetrators must be tried and punished if found guilty, regardless of rank and political status. Over a decade later, there appears to have been little development with respect to criminal investigations and accountability in the Moiwana case. And although the military criminal proceedings were underway in the 8 December murders case, that proceeding was suspended, apparently indefinitely, in light of the amendment to the amnesty law in 2012. We were informed pending a decision by the Constitutional Court, although it is not clear to us that the Constitutional Court exists from the state parties' information that we've been provided. Indeed, it has been suggested that the amnesty law was amended in 2012 to extend it backwards from 1985 to 1980 in order to cover the 8 December murders prosecution of the president and his accomplices. We note that Article 2 of the 2012 amnesty law excludes crimes against humanity, but those are not the only violations that cannot be subject to an amnesty. As we stated in paragraph 18 of General Comment 31, failure to investigate or bring to justice perpetrators of violations of the covenant, such as torture and arbitrary killing, can and in and of itself give rise to a separate breach of the covenant. The view that the new amnesty law contravenes Suriname's international human rights obligations to secure accountability has also been expressed plainly by the UN High Commissioner for Human Rights and also by the Inter-American Commission on Human Rights, which has stated with respect to that law that, quote, laws that seek to leave serious human rights violations in impunity are incompatible with the inter-American human rights obligations. So my questions: do you have any plans to repeal the amnesty law? And if not, how does Suriname plan to comply with its obligations under the covenant to investigate, prosecute, and punish gross human rights violations, including acts of torture and extrajudicial killing? Second, we understand that the criminal proceeding in the 8 December murders case has been suspended, apparently to obtain a decision of the Constitutional Court regarding the legality of application of the amnesty law to that case. In your third periodic report, you stated that the draft law to establish the Constitutional Court was pending before the National Assembly. My question, therefore, is what is the status of the planned Constitutional Court? In the absence of a Constitutional Court, is it possible for the court with jurisdiction over that case or another court to address the constitutional question regarding application of the law to the 8 December murders case? Finally, with respect to that particular case, can you explain why the military court trial of Edgar Ritfeld was resumed in relation to that case, but not the trial of the other co-accused? With respect to the Moiwana case, we welcome your observation that the amnesty law does not apply to this case and to the judgment of the Inter-American Court of Human Rights. We also note that you take the position that the judgment has been mostly implemented, although no criminal investigation has been completed. Could you please provide us with further information regarding the reparations that have been provided to implement the Moiwana judgment, including the provision of compensation and restoration of property rights? Please also provide us with information on the current status of the criminal proceedings in this case, including the measures that have been taken to, 1, ensure protection of potential witnesses, 2, identify other sources of evidence in addition to witnesses, such as those identified by the Inter-American Court, and 3, to investigate allegations of state obstruction of justice, as also directed by the Inter-American Court of Human Rights. I appreciate your attention and I look forward to your responses. Thank you.
Thank you very much, Ms. Cleveland. And now I pass the floor to Ms. Shelik. You have the floor, madam.
Thank you. Thank you, Mr. Chair, and welcome back from New York, and good afternoon to everybody. I would like to extend my warm welcome to distinguished delegation of Suriname and to thank you for your presence and readiness for dialogue that we appreciate highly. Also, I would like to thank the delegation for the replies to the questions that they sent. And however, I have several follow-up questions. Today, my interest would be primarily focused on the issue number 9, regarding violence against women, including domestic violence in connection with Articles 3 and 7 of the Covenant. Having in mind state parties' obligation to ensure the equality in enjoyment of civil and political rights set forth in the Covenant, as well as the legal guarantee that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment, and having in mind the factual situation that domestic violence is present in the state, can you please address in more details the fact of not high number of reported cases and at the same time high level of conditional dismissal in 2014 and 2015 that we can see from the Annex 2 that you sent? In addition, please update the committee on what were the court and other relevant measures undertaken against the offenders. As you have recently replied to the committee's list of issues, In 2009, the Act to combat domestic violence was adopted in order to combat violence against women. Did the situation change in favor of better protection from domestic violence since the Act has been adopted? Since we have statistics only for 2 last years and the law has been implemented for 5 years and more. Also in your replies you mentioned different types of training for police officers. Please, can you address what types are in question? Are those training aimed to all ranks of police officers, junior and senior ones? In your introductory speech, you mentioned that also inspectors were trained, but I didn't see if that is related also to domestic violence and violence against women. What has been done towards raising awareness in a society and sensibilization of mentality concerning eradication of domestic violence and cruel, inhuman and degrading treatment towards women? It is encouraging information that the state party has organized trainings on domestic violence for judges, public prosecutors, social workers, as well as for the staff of Ministry of Justice and Police. However, raising self-awareness of women, not only victims of domestic violence, but also as a preventive measure, is important. Please elaborate on how do you address the issue of raising self-awareness and assertiveness among women in Suriname. It is also positive that you reported that you have started with organizing trainings for trainers regarding domestic violence. How many such trainings have been undertaken? Have they been organized throughout the country? And when did you start with this practice? You also reported about organizing of investigative courses in the framework concerned. Please, can you elaborate more on this? And finally, having in mind that sexual harassment in the workplace is criminalized in your respective legislation, I'm wondering if it is the case with the mobbing as well. In this regard, please can you elaborate on paragraph 177 from the state report concerning what particular project approached, as you reported, has been carried out in order to combat domestic violence, and what is the project addressing sexual harassment in the working place that you reported? I'm looking forward to your replies and thank you in advance.
Thank you very much, Ms. Jelik. And now I pass the floor to Mr. Barzelashvili. You have the floor, sir.
Thank you very much, Chair. Welcome back, and I warmly welcome the delegation. And let me ask the questions in relation to the issues 12 and 13. During the last Universal Periodic Review, one of the recommendations made to Suriname and not accepted by Suriname was to study the possibility of ratifying UN Convention Against Torture. That was back in 2011. In periodic reports submitted to this committee, it has been mentioned that no concrete actions have been taken towards becoming a state party to this convention. And I would very much appreciate the views of the delegation regarding the reasons or reservations which do not allow Suriname to become a member, and if there are any plans, not in a distant future, to do so. I took a note of the information that Constitution of Suriname and its Chapter 5, which deals with basic human rights and freedoms, and in particular Article 9, prohibits physical and mental torture. I would also appreciate more detailed information about the national legislation which defines the crime of torture and how it is defined. Does it cover cruel, degrading treatment and punishment as well? To what extent, from your point of view, the law responds to the requirements of our covenant and its Article 7 in particular? And what are the penalties for the torture or inhuman, degrading treatment? During the recent years, there have been
a number of reports by human rights groups, defense attorneys, and media about the mistreatment by police, including beatings while in detention. There have been reports of isolated incidents of abuse of prisoners by prison officials. And naturally, my next question is related to the measures, the steps taken by the state party in response to those allegations. In 2004, in the concluding observations, this committee expressed concern regarding lack of independent mechanism, which will be in charge of investigating allegations of ill treatment and sexual abuse in custody. In the report, as well as in the responses to the previous concluding observation, the state party indicated that Attorney General, which is an independent body, independent in its nature, the Office of Attorney General is in charge of the investigation of crime of torture. And it is my understanding that Attorney General belongs to the judiciary. It's not like every prosecutor, and that's what makes, from the point of view of the state party, this office independent. And however, it's not clear if Attorney General investigates all cases of torture, and if it is obliged by the law to respond to all the cases of torture. In the report, you also refer to the division in the Ministry of Justice and Police, which can be approached by the citizens with the complaints about mistreatment or maltreatment by law enforcement officers. It is further mentioned in the report that, and I quote here, that in cases of justified complaint, the Attorney General's office is competent to conduct an investigation. However, it's not clear how and when these complaints are forwarded to the Attorney General. Does the initial assessment of the complaint made by the police itself? On what basis it decides to forward the complaint to Attorney General, and to what extent this division may be considered as independent. Let me also express regret that despite the request, the committee was not provided with the detailed statistical data on torture-related crimes, number of prosecutions, etc. However, in your replies, you have indicated that state conducts zero tolerance policy when it concerns unlawful police actions, and you also mentioned that there are more than 600 complaints only in 2013 against police officers, out of which 374 have been investigated and individuals were found guilty. I assume that these complaints deal with all sorts of misconduct and not only of cases, and they don't only relate to the cases of torture or beatings. So I would be interested to learn what is the percentage of torture-related crimes, and what is the percentage of successful investigation out of those. In paragraph 59 of your report, it is mentioned that sexual abuse of detainees is taboo and rarely reported by the detainees. Acknowledgement of the problem is obviously very important, and it is the first necessary step. However, I would be also interested to learn what measures the state party took or plans to undertake in order to improve prevention, reporting, as well as investigation of cases of prisoners' sexual abuse. And in general, how many cases of ill treatment or torture have been reported in prisons? And what is the percentage of the investigations and results of the investigation would be also interesting. Let me also inquire if there are any mechanisms in place to ensure monitoring of the psychiatric hospitals. Have there been any reports or investigations of allegations of mistreatment or torture in the hospitals? In the replies which we recently received, you have also indicated that state-established National Human Rights Institute, and Mr. Rodriguez-Racia referred to that information as well. So I would be interested to know also what would be the role of the Institute in terms of the torture prevention. Would it have a function in that regard? Will it have a power to monitor places of detention or psychiatric hospitals? Will it have a power power to report or even investigate the crimes of torture. Let me now move to the next issue. There are a number of reports which indicate that arbitrary detention, harassment, and torture against LGBTI people, especially transgender women, continues to be practiced by security forces or police forces. I took a note of your statement that no facts of harassment or persecution of LGBTI exist in the country. However, could you please comment on the reports that every weekend evening in Paramaribo city, there are regular so-called cleanups, which means that gays and transgender sex workers are arrested and brought to the police station where they allegedly suffer degrading and humiliating treatment. They are believed to be held for several hours without reason, and if they report beating or even rape, their claims are not taken seriously. According to the reports of NGOs, in September of last year, 2 transgender sex workers were arrested and brutally beaten by police officers. And in replies of the state party, you did really refer to this case and informed the police officers who were involved in the beatings have been dismissed from their posts. And I would just like to know if the investigation in this case has been already accomplished and and the case is closed, and if there are any other, if apart from the disciplinary measures, are there any other penalties that might be applied in this case? And final question would be, well, or rather request for the comment would be following. Does the delegation see that LGBTI individuals are more vulnerable in terms of their relationship with the police, and what steps have been or planned to be made rather in response in this regard? Thank you very much in advance for your answers.
Thank you very much, Mr. Bardellashvili. I don't see another colleague. Muy bien. Vamos entonces.
So, we will now adjourn for a few moments in order to provide the delegation with time to prepare answers to the questions asked. And then following that round of answers, we will allow members to ask follow-up questions, which is part of our normal working procedure here in the committee. So, ladies and gentlemen, we'll return here at exactly 4:50 p.m., 10 to 5. So we will resume our meeting then. Meeting adjourned.